So passing a resolution by postal ballot and this is a insertion into the Companies Act that provision for passing. You can pass a resolution by a postal ballot is through or by post. We can pass resolutions of the company meetings. Why this reason for inclusion of this provisions into the Companies Act? Because of the low attendance of the members of the company at the general meetings of the companies. So Company Acts provides for voting through postal ballot, including voting by electronic mode. So by post we can send the ballot papers, and this is a voting by post. You can do voting by post because sometimes it is not possible for the members to present personally in the meeting. So they can also exercise this right to vote through postal ballot or through by electronic mode. It is limited to specified resolutions proposed to be passed by a listed company. The central government has framed rule in this regard for the purposes of passing of resolutions, company resolutions. If it is not possible for a member to present in person in the annual general meetings of the company or general meetings of the company, annual general meetings of the company, in that case the member can exercise his right to vote into the meeting through or by the use of the postal ballot, passing of resolutions by postal ballot. So through he or she can send his voting by postal ballot, so by post. So central government has framed this rule in this regard. Postal ballot includes voting by post or through any electronic mode. Section 2, subsection 65, and applicability of this one-person company and any other company having members up to 200 are not required to transact any business through postal ballot. Meaning is that this is not applicable in the case of one-person company and any other company whose member limit is up to 200, and they are not required to transact any business through postal ballot. Then e-voting is electronic. E-voting is electronic voting. The full form is electronic voting is here. So e-voting is there, or voting by the electronic means is there. So voting by electronic means or electronic voting system means a secured system based process of display of electronic ballots, recording of votes of the members and the number of votes polled in favor or against such members. Suppose appointment of directors of the company, suppose appointment of auditors of the company, or reappointment of directors of the company, reappointment of auditors of the company, appointment of any important medical officer of the company, any other chartered accountant into the company. That we can do a voting in the favor of that particular person, in the against that person we can vote through or by the use of electronic means or through or by e-voting system. We can exercise our right to vote in the meetings of the company. Electronically we can exercise now, because everything is digital. In the digital world we can do exercise the right to vote by using the electronic means of voting that is available to the members of the company to exercise their right to vote in the general meetings of the company or annual general meetings of the company. But this right is only exercised by the members. I already explained you. This right is only exercised by the members, not by the proxies, and not by his wife, his spouse, and his son, daughter, and brother and sister, relatives and friends. They are not allowed to vote. Only members are allowed to vote in the e-voting system. So members of the company, they can exercise their right to vote in favor of that person or against that person to pass the resolution in the general meetings of the company. So all the votings is counting in an electronic manner in the electronic registry at the centralized server, and with adequate cyber security is there to maintain the transparency of the records of the voting and to secure the electronic voting, e-voting is. Then proxies, very very important term, proxies in company meetings. This is very important term to be noted down. The term proxies in the meeting. Who is called as proxy in the meeting? The person you authorized to attend a meeting of the company on your behalf in writing, and it is authorized by the articles of association of the company that that person can act as your proxy to attend board meetings or annual general meetings of the company on your behalf. In that case only that person can act as a proxy. Otherwise you have to present in person, and if you are not present you are counted as the absent in the meeting of the company, that is your absence. And if quorum is not present, in that case proxies are present. So as per the approval of the central government or as per the order of the National Company Law Tribunal, the proxies are allowed to present and complete the quorum of the meeting. And if only one person present as a proxy, that person is counted as a quorum for the meeting as per the order issued by the National Company Law Tribunal for the appointment of proxies in company meetings, whether it is annual general meeting of the company or any other meeting of the company, EGM of the company or any other class meeting of the company. If it is authorized to do so, the proxies are allowed to sit and in the board in the meetings of the company. So then the following are the provisions of the Companies Act regarding the appointment and rights of proxy. And law entitles every member of a company to appoint a person as his proxy to attend and vote at the company meeting instead of himself, as per section 105 subsection 1. There are certain provisions given sections in regard to the appointment and rights of proxies in the company meetings. So law entitles every member of a company to appoint a person as his proxy to attend and vote at the company meeting instead of himself, or you can write herself also, because now women are in picture, women directors are there in the company, so we can use the word himself or herself also. So however but it is not mentioned in the law the herself, but I am giving it the word herself you can use. Now women are in picture, women are the directors of the company, women are in the boards of the company. So women are now in everywhere, in every field. So law entitles every member to present in person with the help of his proxy to attend and vote at the company meeting instead of himself or herself. A member of the company having no share capital does not have a right to unless its article association provides expressly this right to appoint proxy. The member of a company who is having no share capital, so member does not have a right to appoint proxy unless until articles of association of the company authorize you to appoint the proxies on your behalf to attend your meetings and to write to vote into the meetings of the company. This is as per section 105 subsection 1 of the Companies Act 2013. Then point number 2 in this, a member of a private company is not entitled to appoint more than one proxy to attend on the same occasion unless its articles provide otherwise. So member of a company is not entitled to appoint more than one proxy, meaning is that only one proxy is entitled to attend on the same occasion. Suppose 2 meetings are there, you cannot appoint 2 persons as a proxy to attend 2 meetings. So if a member of a private company is not entitled to appoint more than one proxy to attend on the same occasion unless article provides otherwise. You can only appoint one person as your proxy to attend meetings, not more than 2%. So, a member of a public company may appoint more than one proxy. He may appoint one proxy in respect certain shares held by him and different proxy for other shares held by him. That is possible in case of public company, but not in case of private company. In private company, you cannot appoint more than one proxy for the different type of shares which you are having in the company, have contribution into the company in the form of shares. You can't appoint two proxy for different type of shares you have into the company, but this right is available to public company. Public company can appoint the members of a public company can appoint more than one proxy in respect of a certain number of shares held by him, or for a different proxy for a different number of shares held by him or her. So he or she can appoint a proxy for different types of shares to attend the meetings of the company and to write to vote into the meetings of the company. Another point in this, there's a note in that any person can be appointed as a proxy whether he is a member of the company or not. Okay, any person can be appointed as a proxy. Any person you can appoint as a proxy, because you are whether you are member of the company, because you are appointed by the member of the company as your proxy to attend meetings of the company, to discuss, to sit in the deliberation discussions in the meeting of the company. So any person can be appointed as a proxy, but the person who appointed proxy, that person should be a member of the company. Only that person can appoint proxy, not other persons. Suppose you are not member of the company, how can you appoint your proxy? You cannot appoint. Only a member of the company can appoint his or her proxy. Suppose you are not a member, but you are a wife of a member, you are a son of a member, you are a daughter of a member. You cannot appoint proxy for your father, for your mother as a member of the company. No, you are not member. Only a member of the company, the valid member of the company, that person has a right to appoint proxy in the company meetings. And proxy can be any person, but proxy must be appointed by the person who is the member of the company, and he shall have no right to speak at a general meeting unless the article otherwise provide. So AOA must be authorize you to speak in the general meetings as a proxy. Unless until if it is not authorized, you have no right to speak, but you have a right to sit in the meeting and to see and to note down the discussion and deliberations in the meeting. You have a right to note down, but you don't have a right to speak unless until articles of association authorize you to do so, to speak at the general meeting and to fight for the rights into the meeting. So every proxy, a proxy is ordinarily entitled to vote only on a poll, but he may not voting by show of hands if the articles provide. Okay, so he may vote, proxy may entitled to vote if articles of association of the company authorize you to vote into the meetings of the company. But ordinarily you can vote. Ordinarily as a proxy, you can vote by poll, but for voting by show of hands, you have to take permission, you have to take approval from articles association. It must be authorized you. It must be mentioned in the articles of the company that any member of the company can appoint his or her proxy to attend board meetings and can vote in the meetings by show of hands. That must be authorized you. Then only you can vote as a proxy. Otherwise, you cannot vote as a proxy into the meetings of the company. So proxy must be appointed by an instrument in writing, duly stamped and signed by the members of the company. A blank stamped proxy is valid and may be completed by the person authorized to do so. So proxy must be appointed and instrumented in writing. It must be in writing. If you are authorizing someone else as your proxy, that person must be authorized by you in writing. With your signature is must be there that I am authorizing such and such person to attend this meeting of the company on this and this date and this and this time to discuss this agenda. Kindly accept that person as my proxy and allowed him to sit in the meeting and to note down the discussions and deliberation into the meeting. So it must be authorized by the person concerned who is the or who must be a member of the company. A blank stamp proxy is valid and may be completed by the person authorized to do so. This separate application form you have to fill to appointment of the proxies into the company, and that with your signature and your authentication, your stamp, that makes that document valid to attend the general meetings of the company. A blank but stamped proxy is valid. Blank paper is not valid. Blank, nothing is mentioned. It is not valid, but it is stamped, it is signed, then it makes your document a valid document. Signature and stamp is very important. Signature affixed attached with the common seal of the company or stamp of you, that makes that document valid to present in the court of law in the case of any dispute in respect to the appointment of proxies and all. Suppose you think that proxy is criminal person, the person you appointed, that person is criminal. There are so many criminal records against that person, and you appointed that person as proxy. So you must authorize that I am responsible for the appointment of that criminal person, and you have to be the consequences of the appointment as proxy. So it must be authorized by the members of the company that this person present on my behalf, and that person represent me on my behalf in the company meetings and vote on my behalf. If later on we find that that person is criminal offences is against that person, some civil offence is against that person, so you are responsible as a member of the company for the appointment of that person. So you have to pay the compensation and consequences as imposed on you by the court of law. If that person is past record is criminal, and civil offences also imposed on that person, because you are appointing someone else. Company is not responsible. You are appointing your proxy, and you are authorizing that person. We are just only accepting. Meaning is that any person can be appointed as proxy, whether he or she is member of the company or not. But he or she must be appointed by the member of the company. That is a clause in that. That is a note in that. So every person can be appointed, but you should have a record of that person. That person should not be criminal, should not have any past records, pending records in the cases in the court of law. That person should be no any pending cases in the court of law. That person should be authorized person, should not be criminal, should not any cases pending in the court of law, and should be a sound mind person, should not be insane, should not be. Meaning is that competent person should be appointed. That person should understand the terms and conditions of the meeting. What we are discussing in a meeting, if you are not able to understand what is the point of attending a meeting, that person should be sound enough, should be knowledgeable enough to attend the meetings of the company on your behalf. That person should be your representative and in true sense. Otherwise, there is no point of attending meeting. That is a mere waste of time and all. So that person must be authenticated person, authorized person, must be valid person, true person, should not be a fake person and all, because that person representing you, representing your name, your goodwill, everything, that person should be your true representative, should attend meeting in a true sense and recording all the things what we are discussing in the meeting in the notes, as a note in the register or in the copy. That makes proxies valid into the meeting. Otherwise, it is not valid. So next point in this, every notice of a meeting must be appropriately mentioned that a member is entitled to appoint a proxy, and that the proxy need not to be a member, as per section 105 subsection 2 of the Companies Act 2013. It must be mentioned in the meeting, it must be mentioned in the notice of the meeting that a member can appoint his or her proxy, and that proxy, the condition is that a proxy need not to be a member of the company, but the person who appoint the proxy, that person must be a member of the company as per this particular section, section 105 subsection 2 of the Companies Act. So company cannot send invitation to members to appoint any person or one or more person as proxy. Okay. So this is given to you by the company. Okay, and it is mentioned as a note in the meeting that you can allow to appoint your proxy. If it is not possible for you to attend in person, you can appoint someone else as a proxy in writing, stamped by you, and that person must be representative of yourself to yourself, and we allow that person to attend meetings on your behalf. So company cannot send invitation to members to appoint any one person as proxy. There is no as such invitation sent to you that you are inviting to appoint. No, it is mentioned in the notice of a meeting that proxies are allowed to attend the meeting of the company on your behalf in writing, authorized by you, stamped by you. Okay, so in that case, there is no as such invitation sent to you by the company for the appointment of proxy, one proxy in the case of private limited company, one or more proxies in the case of public limited company. For different classes of shares, you can appoint more than one proxy to attend different meetings on your behalf. But that is not possible in the case of private company. You can only appoint one person as your proxy to attend similar occasions of meeting. A proxy is revocable. Revocable means withdrawable. It can be revoked at any time. It can be cancelled at any time. Okay, at the will of the member of the company. So proxy is revocable. It is withdrawable. It can be revoked at any time. Death of the member appointing a proxy will, in the absence of provisions of the Act, revoke the authority of the proxy. So, in the case of death of the member is not personally present, cannot be able to present because he or she is not present in this world. He or she is died. So, death of the member appointing a proxy will, in the absence of the provisions in the articles, revoke the authority of the proxy. The proxy meaning is that proxy is revocable. It can be revoked at any time. Suppose you are present and you wish to attend, even after giving your intimation in advance to the company that this person attend meetings of the company on my behalf, and kindly allow that person to attend the meeting. So anytime you can revoke your revoke your message, revoke your whatever you said to the company, your letter or information application to the company. Anytime you revoke that application for the appointment of proxy, and you can attend your meeting in person. But death of the member appointing a proxy will, in the absence of the provisions of the articles, revoke the authority of the proxy. If article, meaning is that article is very important document. If article authorize you to attend a meeting, even in the case of death of a member, you can attend as a proxy. But if article does not authorize to you, then you can attend as a proxy the meeting of the company. Then relationship between the member and proxy is that of principal and agent. Because member appoint you, member is your principal, you are act as an agent of your principal, you are act as an agent of your member. So you have to represent your member in a better way, in a true way, and make a record of each and every transaction, each and every matter discussed in a meeting, and inform to your member that today I am attending this meeting and this matter is discussed in a meeting and this resolution has been passed in a meeting. So the proxy and member relationship is of that of a principal and agent. So they have this type of relationship. The proxy is act as an agent, and the member, the person who appoint the proxy, that person is called as a principal for the proxy. So it is a duty of the proxy to attend the meeting in a diligent manner, in a very attentive manner, active manner, and make a records of the deliberations and discussions in a meeting, and take a note of that, and submit a copy of note to the principal, to the member, that this matter has been discussed in a meeting and this resolution has been passed in a meeting by voting. And you can also vote in a meeting if articles or session authorize you to vote into the meeting. So the person, the member of the company has a right to appoint proxy, and that member must be a major, not minor. So minor means who or she has not completed 18 years of his or her age, so that person is called as minor. So minor is incompetent to enter into any contract. So a minor member has no capacity to appoint a proxy. Although you become member of the company, but you have no right to appoint a proxy to attend meeting on your behalf. Meaning is that you have to attend meeting on your person. You cannot appoint any other person to attend meeting on your behalf. The meaning is that as per the Indian Contract Act, minors are not allowed to enter into any, they are incompetent to enter into contract. As per the age limit is there, so you have to complete 18 years of your age for the purpose of the appointment as a member of the company, or for the purpose of appointment of a proxy of the company. So he can only act through his guardian. Guardian means the principal. So member is his or her guardian for the proxy for the minor. So minor can be appointed however minor can be appointed a proxy. Means minor can be appointed as a proxy, but minor member cannot appointed a proxy. This is a note in this. Meaning is that a person who is a minor member has incompetent to enter into any contract, but he is a member of the company, but have no right to appoint a proxy in his or her behalf to attend meetings of the company. But minor can be appointed. A minor person can be appointed as a proxy. Then come to the principle of majority rule. That is a principle. Rule of law is that let's say this is a majority rule in the company meetings. Very important. Those who are in favor of the appointment of that person, and majority of persons are in favor of the appointment of that person, and that person resolution is passed because majority is in favor. The special resolution is there, at least 70% of the person to vote in the favor of the appointment of that particular person, and the appointment is passed in the meetings of the company. That is a rule of majority is there. Those who have the maximum number of shares into the company, have a major interest in the company, major stake in the company, and they enjoy the rule of majority is there. They enjoy substantial shares they have, so they have a right to enjoy the voting process. They have a right to maximum vote into the meeting, to pass the resolution into the meeting, whether ordinary by nature or special by nature. This is a principle of majority rule, and that is applicable to the management of the company, and the members of the company pass resolution by simple majority. In certain cases, 3/4 majority is required, and once the required resolution is passed, it becomes binding on all the members of the company. You have to enforce, you have to comply with all the resolutions which is passed in the meeting, and you have to accept and applicable all those resolutions as a member of the company. So the company stands as its artificial legal entity concept, and directors run the company on behalf of the company, and directors, they are the substantial shareholders of the company. Sometimes they run the company for their own stake and they overlook the interests of the company. So sometimes there are certain exceptions to this rule, and sometimes you need to find out the person who actually runs the company. Sometimes majority tries to harm the interest of the minority shareholders, minority of the company. In that case, there is a need to find out the persons who are involved in that case. And because a company cannot speak, company speak by its members, and if its members are indulged in some wrongful activity, some ill activity, and they are in regard to the appointments of directors, in regard to the reappointment of directors, in regard to the appointments of auditors of the company, chartered accountants of the company, liaison officers of the company. In that case, there is a need to find out the persons who are really involved in that appointment and all, and because of that, the decision is impacted in the meetings of the company, and accordingly we have to pass the resolutions in the meetings of the company. That is a principal majority rule. Majority are in the favor of that particular resolutions, either by some pressurized element is there, some force element is there. So company stand as an artificial legal person. Directors runs the company on behalf of the company, and director accept the resolution passed by the majority of the shareholders, members of the company, and overlooking the interest of the minority shareholders. So majority rules the minority, and majority supremacy in the company, but there are limitations in the powers. There are certain exceptions to the majority rule. If a majority tries to harm the minority, that case there is a need to find out the persons who are indulged in that wrongful activity, ill activity of not protecting the interest, not taking care of the interest of the minority shareholders. Majority of the members of the company, they are in the favor of the suppose in the favor of the wrong decisions. In that case, is a need to interfere in the rule of majority, that is exception of majority rule. So rule is not absolute for the majority. The minorities also have certain protections. That's why I'm saying exception to the majority rule. Sometimes directors, they are not working for the betterment of the company. They are working for their personal betterment. They are working for their self-development. They are working for their personal goals, personal desire, personal wishes, and they are working to fulfill their objectives, not for the objectives of the company. The objective is to cheat the company, fudging of accounts of the company, manipulation of accounts of the company. That is their objective. In that case, there is a need to find out the persons who are indulged in that activity, wrongful activity, inappropriate activity that is not acceptable in the court of law. In that case, we need to find out the persons. And here the principal majority rule is not applicable. That is the exception to the rule of majority. Ultra-wise act is there. So individual shareholders can take action if they find that the majority has done an illegal act or ultra-wise act beyond the aim of the company, beyond the MOA of the company, and they indulge in that particular activities without notice of the company, without notice of the members of the company. And in that case, there is a need to find out the persons who are actually in default then they have to bear the consequences of non-following the provisions of the Companies Act and provision of the Articles of Association of the company. If it is not authorized to you to, and you borrow the loans for the company without having proper authority to do so, then in that case you have to bear the consequences of your inappropriate action on your part. Then fraud or minority. If the majority commits fraud or minority, in that case minority can take necessary action against the majority. And if the objective is to fraud with the cheating with the minority, in that case court will decide the amount of compensation to be paid to the minority by the majority. So in that case, the intention is to do fraud. Intention is to harm the minority shareholders of the company. In that case, on the appeal filed by the minority shareholders to the National Company Law Board, in that case, the board may issue an order to the company that minority shareholder interest to be protected by the company. In that case, the person indulged in that fraud element, they have to pay the consequences of indulging in fraud. The next point is wrongdoers in control. And if the company is in the hands of wrongdoers, when directors of the company, their objective is to, intention is to commit fraud with the company. Okay, so wrongdoers, they are controlling the affairs of the company and they are damaging the image of the company, they are misusing the image of the company, they are spoiling the image of the company in the market, in general public, to general public. In that case, you need to find out the persons who are indulged in that wrongful activity and taking action, strong action against the persons in order to protect the interest of the minority shareholder who have very less number of shares in the company. But they know what is good, what is bad for the company, and on the application filed by any member of the company, a minority member of the company, then court may issue an order to the company to find out the persons in default and impose a penalty provisions on that. The resolutions requiring special majority. If the act requires a special majority, but it passes by a simple majority, then in that case individual shareholders can take action. Okay, so if the act requires special majority but it passed by simple majority, in that case individual shareholder can take action against the person who indulged in that particular case, and they are passing by simple majority, not special majority. At least 75% of the person should be against the should be in favor of the appointment of the person. In that case, his appointment is passed. Otherwise, it is not passed. Then personal election. Majority shareholders always obliged to the rights of the individual membership, and individual members have a right to insist on the majority, the compliance with the statutory provisions and legal rules. Personal action can take if a majority of shareholders always obliged to the rights of the individual's membership, and individual member has a right to insist on the majority on compliance with the provisions of the Companies Act and legal rules mentioned in the company laws. So you can take personal action against. Then breach of duty. And if there is a breach of duty by the majority of shareholders and directors, the minority shareholders can take action. You can take action against the person who indulged in breach of his or her duty, whether they are acting as a capacity of directors of the company or shareholders of the company or members of the company. If the member of the company founds that any other member of the company who is in breach of his or her duty, in that case that person can file a suit against that person for breach of his or her duty as a minority shareholder of the company against the majority shareholder of the company and the directors of the company and or any other person concerned of the company. Then for prevention of operation and mismanagement, uh, to prevent the operation and mismanagement in the company, the minority shareholders of the company can take action against the persons who are indulged in that operation and mismanagement and ill practices, manipulation in accounts, and can inform to the company law board and to the National Company Law Tribunal, now it is Tribunal, earlier it is Company Law Board, now it is Tribunal, that these persons are involved in the operation and mismanagement case. In case of operation and mismanagement, the rights of minorities can be protected by making an appeal to the central government, which I already told you, already explained you, the Company Law Tribunal and the Court of Law. These agencies have power to prevent operation and mismanagement through the appointment directors as per the Companies Act 2013 or as per the recommendations of the JJR committee, to ensure that there should be a space, platform given to the minority to express their opinion and to safeguard their interest whenever it is appropriate to do so, and provide strong interference by the Court of Law and Tribunal for the protection of the interest of the minority against operation and mismanagement in the company affairs by the majority of stakeholders. There is a point in this: every minority shareholder must be treated as a key stakeholder in the affairs of the company administration, and his rights must be respected as per the values vested in the principle of natural justice, and he must be notified all the key developments and heard by company administration. Meaning is that every minority shareholder must be treated as key stakeholder of the company. Whatever contribution you have, whether it is 1 rupee or 2 rupees or 3 rupees or 1000 rupees or lakh rupees, you have a contribution to the company. Even if you are minority shareholder of the company, you have a right to speak. You have a right to interfere into the company administration, into the management of the company, and you have a right to say yes or no into the meetings of the company. You must be treated as an important stakeholder of the company by the administration of the company, and his rights must be respected as a minority shareholder and must be given value as a point of given in the principle of natural justice. So he, as a principle of natural justice, he or she has a right to interfere into the administration or management of the company as a minority shareholder of the company. He must be notified all key developments and heard by company administration. He or she must be heard by company administration and must be given notification of all the developments happening inside the company, in the company. So he or she must be informed, must be notified by the company in respect of any developments of the company. So in short, in nutshell, the company as a family must value the opinions and interest of every member of the company, whether in the capacity of major shareholder of the company or minor shareholder of the company. He or she must be respected, must be given value by the company. There is a case law in this. Tata Consultancy Services Limited versus Cyrus Investment Private Limited. The case in the year 2021. The facts of the case: Mr. Cyrus Mistry was removed from the directorship of the various Tata Group's company by passing resolutions in shareholder meetings, and Mr. Mistry and his company, which hold as a 50% stake, become minority shareholders of Tata Group companies. And therefore he has challenged removal in the National Company Law Tribunal on the grounds of operation and mismanagement. Cyrus Mistry, because he is a minority shareholder in the company, and he complains to the NCLT on the grounds of operation mismanagement. And NCLT held that there was no operation mismanagement declaration action, and this judgment was reversed when Ministry appealed it NCLT. So judgment of the court further appealed by Tata Group to the Supreme Court of India, and it was held that just removal from the operation position of director is not sufficient ground to conclude that there was operational mismanagement. So that is a judgment of the case given by the Supreme Court of India. It was held, that is a judgment, that is a conclusion of the case, concluding remark of the case given by the Supreme Court of India, that just removal from the position of director is not sufficient ground to conclude that there was operation and mismanagement. Okay. But the exception to the principle that Faust versus hot bottle case highlight essential rights of minority shareholders and which must be exercised when time to time when it arises, and the voice of minorities must be protected by the company administration. This is all for today's session. I hope you all learned so many terminologies of the Companies Act, about the company meetings, about the rights of the shareholders, about the term proxies, who can appoint proxies of the company, about the famous case laws in respect of the rights of the minority shareholders, in respect of the ground operations and its management. And I hope you all enjoyed today's session. Thank you all. Thank you.